Welcome everyone, I'm Attractive Nuisance, and you've stumbled onto Leisurely Law. Today, we're going to clean up some myths and misunderstandings about recent political moves in Canada that involve our constitution. If you've been paying attention to politics in Canada, you've probably heard about Alberta's Premier, Danielle Smith, and the rest of the United Conservative Party making history with a brazen invocation of the Notwithstanding Clause. For our American viewers, the Premier of a province is equivalent to a state governor. For context, the teachers in Alberta went on strike starting October 6, 2025, because their collective agreement expired and a new one couldn't be agreed upon with the Alberta government. This was pursuant to the Alberta Teachers Association, the collective bargaining union for teachers. I won't go into the details of what each side was asking for, but rather I'll just say that the union and the Alberta government couldn't agree. So no new collective agreement was signed, and the Alberta teachers continued to strike. That is, until the Alberta government got tired of negotiating and instead decided to circumvent the union entirely by legislating a back-to-work requirement, forcing teachers to return to work on October 29, 2025. How could the province order this, you might be asking? After all, isn't the whole point of unions to protect employees from being forced to work in unethical and unfair employment? Aren't our collective bargaining rights and right to be associated with the union protected by our Charter of Rights and Freedoms? Aren't they constitutionally protected rights? Yes and no. In Section 3, subsection A of the Back to Work Act, it says, "This Act shall operate notwithstanding Sections 2 and Sections 7 to 15 of the Canadian Charter of Rights and Freedoms." This is an express invocation of Section 33 of the Charter of Rights and Freedoms, a section which permits a provincial legislature to declare in an act that the act operates regardless of, or notwithstanding, whether it violates Sections 2 or 7 to 15 of the Charter, for up to 5 years. In other words, even if an act violates a person's right to assemble, no one can challenge the act for violating those rights because Section 33, the Notwithstanding Clause, was invoked. No one can argue that their rights weren't upheld or that they were injured by their rights being violated because the act says it doesn't matter. To really appreciate the significance of Danielle Smith's recent political move, we first need to understand the history of the Notwithstanding Clause. So let's clean this up a bit. Section 33 of the Canadian Charter of Rights and Freedoms, otherwise known as the Notwithstanding Clause, has been a unique feature of the Canadian Constitution. The Constitution Act of 1982, which is Schedule B to the Canada Act 1982 and contains the Canadian Charter of Rights and Freedoms, was a major accomplishment, legally speaking, because it cleared up a lot of confusion about the Constitution of Canada. But there was still a big issue with how Canada should accommodate Quebec, and this issue had been heavily debated for years before the Act was enacted and after Quebec didn't agree to the 1982 constitutional amendments. Quebec wanted to be part of Canada, but also sought greater autonomy and distinctness as a society. Even so, Quebec has strongly considered separating from Canada. In 1987, the Meech Lake Accord was drafted to reflect negotiations among the Prime Minister and provincial premiers, negotiations which arose after the Quebec Premier presented 5 conditions that needed to be met before Quebec would accept the Constitution Act of 1982. As I'm sure you can guess, these conditions never came to light because the accord was never ratified because 2 of the provinces refused to ratify the accord to make it take effect as law. Then, in 1992, the Charlottetown Accord was negotiated, and it included the terms of the Meech Lake Accord and added some additional terms. But again, this accord never became law because the accord underwent a national referendum before being ratified, and it was decisively rejected by a national majority. In 1995, Quebec held a referendum on sovereignty, asking their citizens whether Quebec should become sovereign after making a formal offer to Canada for a new economic and political partnership, and it was only narrowly defeated by a margin of 0.6%. Quebec's dissatisfaction with the 1982 constitutional amendments and Canada's failure to accommodate them is essential to understanding the history of the Notwithstanding Clause. From 1982 to 1985, Quebec used the Notwithstanding Clause in every new legislation to demonstrate their distaste for and resistance of the 1982 amendments. Quebec has also used the Notwithstanding Clause to support their French language culture. Interestingly, the use of the Section 33 Notwithstanding Clause has historically been unpopular outside of Quebec, and it really contributed to the Meech Lake Accord failing to be ratified. While Section 33 can be invoked by any legislature, it can be understood as being designed to accommodate Quebec's desire to be free from judicial review and repeal. Section 33 was hence written into the Charter as a political compromise to reassure the provinces, primarily Quebec, that their cultural and linguistic policies couldn't be repealed by the courts. The clause wasn't meant to be a way to escape constitutional scrutiny or as a convenient way for legislators to bypass rights that they find inconvenient, but was rather intended to promote democracy and preserve provincial autonomy, particularly Quebec's, in exceptional circumstances. Quebec's refusal to agree to the 1982 Charter, paired with its frequent reliance on Section 33, highlights its long-standing concerns about being accommodated by Canada. For additional background, there's a concept in Canadian constitutional law called dialogue between the branches. The idea is that the three branches, legislative, judicial, and executive, should, and tend to, all be cooperating towards common goals that are in compliance with the Charter. When there's good dialogue, then there's no need for coercion or forcing the other branches to comply. This is part of why we don't see the Canadian Supreme Court strike down many laws, because there's a certain deference and trust given by the court to the legislative branch. Often, when legislation is struck down, the court will offer some kind of alternative that would be constitutional. For example, in RJR MacDonald v. Canada, the Supreme Court struck down legislation that prohibited all advertising for tobacco products. However, the court noted that similar legislation with a more confined reach, such as by prohibiting all advertising for tobacco products that are directed towards children, would be much more appropriate to achieve the legislative goal. In so doing, the legislative branch had dialogue with the court by crafting legislation. The court then reviewed and explained its concerns to the legislative branch, who could then amend their legislation accordingly. The legislation returns to the court for a second look, at which point the court could offer more alternatives for the legislature, and so on and so forth. But why is this relevant? The Notwithstanding Clause is supposed to address the concern that judicial review by non-elected judges shouldn't supersede elected legislators' goals. In other words, it gives legislatures the last word in dialogue with the judiciary, because even if the court finds legislation unconstitutional, the legislature may be able to push it through nonetheless if it falls within the Notwithstanding Clause's categories. It's an attempt to strike a balance and promote both legislative and judicial independence, but it can act to effectively halt dialogue and bar any collaboration with the judiciary. Given that understanding, let's look at how the Notwithstanding Clause operates in the context of Danielle Smith's Back to Work Act. Section 2 of the Charter protects a person's right to associate with a union and to be part of a collective bargaining unit. But the Back to Work Act says that it operates notwithstanding Section 2 of the Charter. So even though union rights are normally protected, these rights are set aside while the Act is in effect. Teachers have a right to collective bargaining, which may include the ability to strike, and to negotiate for a collective agreement, but they can't actually strike or negotiate while the Act is in effect, making them completely powerless against the whims of the United Conservative Party. Even if the teachers request judicial review of the Act and argue that their Section 2 charter rights are violated by the Act, the court can't overturn the legislation for being unconstitutional for charter breaches. There can be no dialogue because Danielle Smith asserted that her party knows best and doesn't need judicial advice, and the courts can't overturn the legislation and offer more constitutionally sound alternatives. In fact, the Supreme Court has previously stated that it won't review a legislative decision to invoke the Notwithstanding Clause. It's not even the last word in this case, because Danielle Smith stopped the conversation before it had even begun. In many ways, both the Alberta legislature and the courts are cut off at the knees by the Section 33 invocation, because the Back to Work Act can't be refined to adhere better to policy and charter values. I know that a lot of academic commentators and lawyers' associations have already spoken out about Danielle Smith's use of the Notwithstanding Clause, and others have defended it as a justifiable protection of provincial powers and assertion of provincial jurisdiction. The existence and use of the Notwithstanding Clause has spurred debate since its inception, but even though the issue has already sparked plenty of discussion, it's imperative to continue to draw attention to the blatant disregard for Alberta teachers' charter rights. The Back to Work Act fails to serve and protect Albertans, instead undermining the very rights it should uphold. It contradicts the original spirit of Section 33 and perpetuates the very harm the Charter was meant to prevent. More recently, it seems that the Notwithstanding Clause is being used in precisely the ways critics warned it might, as populist politicians leverage reactionary and identity politics to justify broad overrides of rights. A government that exceeds its authority and acts against its own citizens undermines democracy itself. I want to note here that the Notwithstanding Clause can be invoked in any legislation, provincial or federal. Federal Parliament has never invoked Section 33, and the provinces, mostly Quebec, which makes sense due to the history of Section 33, have only rarely asserted the Notwithstanding Clause. This means that, if it wished to, the federal government could write legislation affecting all of Canada and invoke the Notwithstanding Clause to completely ignore people's rights for 5 years. That's the kind of power you're supposed to handle with care, and not just spray wildly across the surface of our rights. Whether you see the Notwithstanding Clause as a safety net to protect from judicial errors and overstepping, or as a defect in the Canadian Constitution because fundamental rights shouldn't yield to politics, we need to be cautious of why and to what extent our legislators are invoking the override. I don't think it's a reasonable argument either to suggest that the judiciary shouldn't have authority to review legislation. One of the most impactful effects of the Charter is how it expanded judicial review to ensure that rights are being supported. So it relies on the assumption that legislation will promote policy objectives, and the judiciary will review the legislation to make sure that it adheres to Charter rights and values in achieving those policy objectives. If we remove the judicial review aspect and permit legislative goals and policies to override individual rights and freedoms, then there is no recourse. Our rights will be trampled and left undefended. For this reason, and so many others, it's imperative that legislatures and the judiciary branch work together. Like I've said in previous videos, this isn't just about the teachers. It's about the epidemic of the erosion of our rights that's creeping into Canada. Legislation like the Back to Work Act aren't innocent interventions to keep schools running or to benefit the children. They're slow, subtle political moves that are meant to exploit citizens, and politicians are getting so much bolder as they realize that no one is stopping them. People say they want their rights upheld, but what really matters is what's happening on a grander scale, because when governments take away rights at the collective level, individuals lose them too. Unions exist to protect our people, and the Charter protects the right to be in those unions, to support employees, and to prevent an employee-employer imbalance that so often oppresses employees. Even if you're not a teacher, or you're not in Alberta, or you're not in a union, the Back to Work Act signals a willingness by Alberta's United Conservative Party, and of other governments, to literally write off our rights. If they can do this, then they can legislate away things like practicing religion, accessing the news, or posting opinions on social media. Because the Notwithstanding Clause also applies to Sections 7 to 15 of the Charter, it could, in theory, be invoked to allow laws that permit cruel and unusual punishment, unlawful detention, or even deprivation of life. All of these impact our society, and any one of them could affect you individually. To conclude with a hearty dose of legalese, notwithstanding the foregoing, when we clear away the confusion and the grime clouding our view, all the noise and the politics and the corruption, we may find that our rights and the shared values underneath are truly beautiful and worth protecting. Thanks for tuning in today. I'm Attractive Nuisance. This is Leisurely Law. I'll catch you next time.